In an unusually public display of ignorance, arrogance, and sense of entitlement, a Kentucky prosecutor has sued the local police for refusing to give him and his wife special treatment via an emergency escort to the hospital. Yep, this one's a doozy. Let's talk about it. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. So this is kind of a crazy case, right? There's an assistant Commonwealth attorney named Joshua Price who works in Whitley County, Kentucky. That'd be like right up the road from where I am right now, about 70 miles. That's exit 11 on I-75. Just like 11 miles from the Tennessee-Kentucky border. The whole incident was sort of born out of his wife cutting her hand, and he wanted to call and ask for a police escort so he could speed without consequence to get her to the doctor. The whole thing could have likely been accomplished by saying, hey, if you see this vehicle traveling on this road, this is me, my wife's bleeding, tell the police I'm not stopping and I'll deal with the consequences when I get to the hospital. But that's not what he did. So I don't want to go too far into the details. We've got a news story from LEX18. I'll let him tell it. We'll stop and talk about a couple things along the way. Let's check out the story.
And prosecutors are working together to fight crime, and that's the case in Whitley County. But in tonight's LEX18 Investigates, our Lee Searcy looked into an unusual situation that's now headed to court for another reason. It raises the question, how far should professional courtesy go?
Are you talking about me?
I am exactly talking about you. 100% talking about you.
Okay. Well, let's talk about it.
We don't need to talk. Me and you don't need to talk. We don't need to say words to each other at all. Me and you and Stephen Hill don't, but we don't need to speak.
Well, that's
because my wife almost died Friday, and you and Stephen Hill said on your hands what happened.
A tense exchange between an assistant Commonwealth's attorney and the Williamsburg assistant police chief. It came moments after the prosecutor made this comment.
I'm gonna tell you right now, if my wife would have died, we'd have had us postal situation on our hands.
So I just want to pause here and say it cannot be overstated how reckless and irresponsible it is for an attorney, especially a prosecuting attorney, to make a statement like what he just said. Look, you can spin it any way you want to, but there's no other connotation that going postal can have outside of a veiled threat to shoot somebody. If you say a postal situation, what you mean is that you want the other person, the receiver of whatever communication you're offering, to believe that you would have been willing to kill someone over not getting your way, or had there been some sort of permanent negative consequence as a result of them not acting in accordance with what you thought they should have done. Now, this Commonwealth's attorney, Ronnie Bowling, has come out basically and said that he's had a conversation with Mr. Price about the things that he said and courtroom decorum, and that he's otherwise an exemplary employee. Look, this is not a decorum problem, okay? That is a window into his arrogant, ignorant, and entitled character, and he has no business working in government. We'll get to more of that a little bit later.
Prosecutor Josh Price referred to a personal emergency that happened just days earlier.
Whitley 911.
Who's 10-8 in the city?
On May 30th, he called 911 asking for a city police escort to the hospital after his wife cut her hand.
Right now, I need somebody in the city. This is Assistant Commonwealth Attorney Josh Price. My wife's cut her hand very badly. I'm trying to get her to the hospital. It's an arterial bleed, but I've got people in front of me going 12 miles an hour.
Do you want us to have an ambulance meet you somewhere?
No, I don't want an ambulance. I need Dorman or one of my guys. I need an officer to call me on the phone.
What'd you say?
The Williamsburg city officers never called Price. Police say they were busy on other calls.
One of the things that sort of initially struck me, and I'm speculating, I could be wrong about this, but I have some suspicion that maybe in a previous career, Mr. Price was involved in law enforcement. The reason I say that is because when the 911 call started, the first thing he said was, who's 10-8 in the city? That is cop speak, emergency services speak. 10-8 means on duty and ready to accept a call or ready to serve, right? That's what 10-8 means. So whenever you hear Jeff Gray call somebody a big dummy and say, you can go 10-8 now, he's telling them you can get back to work, you can go back on duty, you're ready to go back in service. That's what 10-8 means. Very few people outside of cops or people who just sit around and listen to scanners and dispatchers actually know what that means. And so for him to say, who's 10-8 in the city and not say, hey, this is Joshua Price. I'm an assistant Commonwealth attorney. I've got an emergency. I'm going to be speeding. Like, he didn't set that up in any way that sounded like a normal, like, lawyer would do it. He sounded like he used to be a cop. Now, again, I might be wrong about that. Maybe he didn't. Maybe he was a firefighter. Maybe he was a cop. Maybe he was in EMS. I don't really know. But he sounds to me like somebody that's familiar enough with cop speak that he felt comfortable talking to the dispatcher in a very informal way with sort of an insider baseball approach to how to get what he wanted. And that may lend itself to why he felt like he was entitled to this level of professional courtesy instead of just being like everybody else.
The Whitley County Sheriff, whose body-worn camera caught the courtroom action, says Price appeared to expect some professional courtesy. He says that would have violated standard emergency protocols.
Legally, we can't do that. So you're really opening yourself up liability-wise if you choose to do that. So I understand why they didn't do it.
Now, the other thing that sort of struck me as downright amazing is that how embarrassing it is that a sheriff, who ordinarily would not be the person that you would expect to completely understand the law, certainly not better than a lawyer, is the person who's commenting about the legal merits and having to explain the concept or dynamic of liability for the benefit of a prosecuting attorney. It's actually something that should embarrass him to the point that he should have had enough self-awareness to never bring public attention to this problem instead of filing a lawsuit. But it actually provides a good opportunity for me to explain something that I think is sort of a public misconception. And I'm really asking you guys to pay attention to this. Just because a person has a law license does not mean they're a good lawyer. Having a law license means only that you've passed the bar exam. And furthermore, the bar exam at its core is nothing more than an aptitude test. It asks, are you capable of thinking in layers and navigating nuance? Are you capable of analytical thinking and test-taking discipline? And then are you willing to cram sort of endless, useless information into your brain so that you can go sit for 6 hours for 2 days in a row and sort of memory dump what you committed to your brain in a way that's cogent enough for you to pass the test? And then can you score high enough such that your scores are higher on the curve line than other people taking the test? And ultimately, are you going to be on the success list? But that's really it. And moreover, just because a lawyer is or appears to be busy, that is not evidence that a person is a good lawyer. The sad reality is that, especially when it comes to civil rights law and 1983 cases, there are so few attorneys that take those cases that anybody can be busy in that area of law if they're just willing to take cases that nobody else wants or wants to take. The vast majority, and I mean like above 90% of people who believe that they have a civil rights lawsuit really don't understand their civil rights and really don't have a civil rights lawsuit. And so if you want to stay busy as a lawyer who works in the 1983 constitutional law space, all you have to do is be basically the equivalent of an ambulance chaser who's willing to take any car wreck case and file lawsuits, understanding that it's cheaper to pay you $10,000 or settle quick than it is to litigate. And I don't say that to sort of disparage people who take those cases. We need those lawyers. I'm just saying, you cannot look. The best way I can explain it is to say this: if you went to some small town and you saw a long line of cars wrapped around the building of your local Hardee's, and I'm sorry, Hardee's, I'm not trying to disparage your business model. I'm just saying it ain't the best food on the planet. You wouldn't look at that Hardee's drive-through line and think, well, they must have really good food. The first thing you'd probably ask is there nothing else to eat around here? That's the same thing you should be thinking about a lawyer who's got the freaking phone ringing off the hook and got a practice full of 1983 cases. There's something wrong with that. You shouldn't take every single 1983 case that comes through your door. 90% of them are better, just are not anything more than frivolous lawsuits.
Well, since that courtroom dust-up, the assistant prosecutor has filed this lawsuit. He's now suing the city of Williamsburg, the police chief, and the assistant police chief for negligence. In it, he claims the assistant chief advised the officers on duty to not assist his fellow officer in his time of need. And it says a cruiser from the department could have shortened the trip in excess of 20 minutes. And due to the delay in getting to the hospital, Price claims his wife may have long-term injuries. Should the officer have done more?
I don't know. I don't believe he could have done anything different. I mean, I think dispatch even offered to have an ambulance meet them at a location, and they refused the ambulance. So I don't know, if you refuse the ambulance, why you'd expect the police to give you an escort.
I reached out to Josh Price for comment, but did not hear back. Williamsburg police say they can't discuss pending litigation. So I then went to Whitley County Commonwealth's attorney, Ronnie Bowling. He didn't want to talk on camera, but sent me this statement that reads in part, quote, "In my eyes, all the vitriol stemming from the verbal disagreement was resolved," and added, "Everyone is committed to working together." He continued by saying he addressed courtroom decorum with Price and called him an exemplary employee.
We work each other out.
Despite this, the prosecutor's office and the police department vowed to be professional and courteous moving forward. In Whitley County, Lee Searcy, LEX 18 News.
For now, Price no longer prosecutes cases involving the Williamsburg City Police Department.
Look, I say this all the time privately to my friends and fellow attorneys. I've learned more about the law talking about the law on YouTube than I ever did practicing law. And the reason I say that now is because a lot of the times that when you're practicing law, you sort of operate with this bundle of things that you do on an everyday basis. And so a lot of like prosecuting attorneys who understand criminal law, they don't know very much about, say, relevant case law. And the reason is because most cases don't get litigated. And you just really don't deal with the same sorts of issues that you deal if you're litigating cases. Most cases settle without litigation, and so you don't exactly keep your sword sharp when it comes to case law. And the kind of stuff that you use case law for during litigation is to try to persuade the person that you're trying to persuade, either the judge or the jury, to see things the way you see them. Case law is an authority that lawyers use to make a persuasive point. And I've been able, because I have time to make sure that I'm giving accurate information and trying to understand the cases, to learn more about case law and how it applies to the facts that we see in these scenarios than I ever knew while I was actively taking as many clients as I could get in the door. And so in some ways, you sort of give people a pass if they're not experts in every area of the law. But even in this case, this guy does not get a pass. And here's why. He sued the police for negligence. And negligence is one of the first things you learn about in law school. You literally spend like your entire first semester of law school in the class called torts, learning about the elements of negligence. And negligence is very complicated, but it can be simplified for the purpose of our discussion. The elements of negligence are duty, breach, causation, and damages. That's how you prove a negligence case, by proving those elements. And I'll break it down even further so I can simplify the explanation. And like the easiest way that I can do it would be like the example of driving a car. Duty very simply means that you have a responsibility to other motorists to conduct yourself behind the wheel of a car in a certain way. It's generally referred to as a standard of care. And so the courts have said that you owe a general duty of ordinary care to conduct yourself like an ordinarily prudent person would when you drive a car. Okay, so that's duty. Breach means that you had a duty to act a certain way and you didn't. Okay, so there's a stop sign, you're driving a car, you're obligated as an ordinarily prudent person to stop at the stop sign. If you don't stop at the stop sign, you've breached your duty. Okay, causation is the causal link that connects the breach of duty to damages. Okay, so you got duty, you were supposed to drive your vehicle in a certain way that exercised ordinary care. That means that you were supposed to stop at a stop sign when you saw one. Breach is where you don't do that. You ran the stop sign, right? Because you ran the stop sign, okay, that's causation. You struck a person who was crossing the intersection on foot. And as a result, that person experienced damages. So duty was the thing you were supposed to do. Breach is the departure from that duty. Causation connects breach to damages and says, because you didn't do this, that caused these damages. Okay, that's how you prove a negligence case. But here's where Mr. Price makes himself look like a complete clown. The negligence analysis dies on the vine the second that you realize that the person you're suing had no duty to conduct themselves a certain way. And why am I bringing this up? Because everybody knows, except Joshua Price apparently, that the police or the state have no duty to a private individual. And I know you guys know that, even though you're not lawyers, because you comment it in every single video that I put out. And most of the people who comment it even know the name of Castle Rock versus Gonzalez. But I'll ask you this, have you actually read the Castle Rock case? Because it's about the murder of innocent children by their estranged father. And in that case, the facts were that the mother had a protective order against the estranged father. And that protective order was violated multiple times, and the police failed to do anything about it. And he ultimately kidnapped and murdered his own children. The mother, with the protective order, sued the police for not enforcing it. And the court said that the police have no duty to enforce a private protective order and that she had no constitutional right to have that individual enforcement of her protective order. Now, I ask you this. If the court saw no private duty in the case of murdered children, do you think there's any world where they find that there is a public duty for the Williamsburg police to stop what they're doing and go provide a blue light escort in a case where the person needs medical attention over a self-inflicted injury and they declined EMS? No, me either. And the fact that this dipshit assistant Commonwealth attorney was so clueless that he didn't even realize that there's no public duty, it should be an absolute embarrassment to Ronnie Bowling and the entire Commonwealth Attorney's office there. And it's even worse for Mr. Price because this dude has actually passed not one, but at least 2 bar exams. I was able to find that he has a Florida bar license, or at least did at some point, in addition to Kentucky. Florida does not reciprocate. If I wanted to go to Kentucky and be a licensed attorney, I could do that. They reciprocate. We could just swap law license privileges, whatever, pay the fees, go through the process. I'm there. Can't do that in Florida. They don't want attorneys from other areas to get rich, say in California, and move down to their beaches and start selling their beachfront real estate and making a bunch of money off of it, okay? Or to go down to Florida highways and become Dan Newland and start suing trucking companies and get millions of dollars in awards and damages. So what they do to sort of prevent that is to make people take their bar exam. So he's had not 1, but 2 bar exams where he's had to answer multiple questions about the elements of negligence. Okay? So it is absolutely pathetic and inexcusable that he doesn't understand this. Or even worse, that he didn't think enough of any other attorney to bounce this freaking idea off of him before he decided to sue the police over something that would make him look so obviously incompetent as an attorney. And there really is no explanation for it other than this. And it's undeniable that he was so ignorant, arrogant, and full of a sense of entitlement that he thinks that he should be able to customize the privilege and power and authority of law enforcement for his personal whims. And for that reason alone, he should be immediately fired for bringing disrepute upon the office of the Commonwealth Attorney and diminishing public trust and faith in that institution for the citizens of Kentucky. Period. End of story. Now, just as one little last note on the sort of crazy slap in the face that is the whole dynamic between the public versus private duty, it really is a misnomer anyway, because the courts say, okay, the state owes you no private duty, but they owe a duty to the public at large. Well, here's why it's a catch-22. The public at large doesn't sue people. Private individuals sue people. So the second that the public at large becomes a private individual who wants to hold them accountable and sue them, they're like, wait. We don't have a duty to a private individual. We have a duty to the public at large, right? So it's a way that they, it's about as authentic as their commitment to transparency. It's not a real thing. It's a thing they tell you so that you'll feel fuzzy at night, so that you'll think they're there to protect you. But I've got a reminder for you in closing as to why that's not the case either. In closing, this case is admittedly sort of outside the norm of the kinds of videos that we typically talk about. But if you strip away the titles of prosecutor or assistant Commonwealth attorney or police officer, whatever, it reveals the sort of underlying cancer that exists in the criminal justice system. And that is that we have people that we've empowered and trusted with the authority and weight of the government who believe that they are entitled to use the system for their own personal gain. And it's rampant. It's not just this type stuff. It's cops running their ex-wives' new boyfriends through the databases to figure out whether or not they have a driver's license. Or it's cops stalking people using the criminal justice databases to try to figure out what their address is, whether they have warrants, whatever, right? It happens all the time. And it can be spun in any number of ways, but the actions of this prosecutor tell me one thing that I just can't get past, and that is that prior to him being rejected for his request for special treatment by this police department, he believed it was his responsibility to give professional courtesy to other members of law enforcement, or Team Blue, or whatever you want to call it. And we know that he believed that because that's what he used as his justification for why he expected them to do it for him. And that means that he can't be trusted to faithfully and impartially execute the duties of a prosecutor. And that he's lost sight of the fact that Lady Justice wears a blindfold. And Mr. Price, she doesn't wear a blindfold because her favorite nighttime reading is 50 Shades of fucking Blue. It's because your wife's hand and whatever she did to it, and I don't say that to be disrespectful to your wife. I've been injured. I hope she's fine. But it's no different than anyone else's hand, okay? And what were they supposed to do? Were they supposed to stop their response to whatever service they were offering to the people that called them for help in Williamsburg so that they could come and treat you and your wife special? Really? That's your argument? Williamsburg has like 5,000 residents and 12 cops. And let's be honest, if you were as important as you'd like the world to think you are, why don't you have their personal phone numbers such that you had to call dispatch and ask who was on duty? I mean, it's 12 people from top to freaking bottom. And you know what else this sort of reminds me of that I didn't even really think about till I started getting into the analysis of this case? I happen to drive up and down I-75 often enough that I know where all these cities are. Williamsburg is exit 11. You know what happened in Laurel County, Kentucky last December? A sleeping, peaceful Doug Harless was shot to death over the execution of a search warrant at the wrong house, and they were looking for the judge executive's weed eater. So you don't have to have this enormously wild imagination to see how you could go from maybe the seemingly innocent attempted customization of the privileges of law enforcement to the most extreme consequences possible when your sole focus is, what do I got to do to keep this guy who's very important in my community on my side? All of a sudden, you're kicking in the door to somebody's house who's not involved and shooting them dead, all because you could not impartially do your job without expecting special treatment in both directions. So shame on you, Joshua Price, and even more, shame on you, Commonwealth Attorney Ronnie Bowling, for trying to push this off as some fucking otherwise innocent, exemplary employee who just made a mistake. No, he just got caught and didn't have enough sense to understand how wrong he was and then doubled down on it by filing a frivolous lawsuit. This wasn't a person of good character making a mistake. This was a magnifying glass to show us all what his character is actually made of. And he should be fired and removed from office because he can't be trusted with the amount of authority you've vested in him or public resources. Anyway, I saw this case, thought it was an interesting case, interesting video to talk about. If I get more information or something else comes out, I'll probably include it in the next week's episode of The Rebuttal. But in the meantime, I'd like to invite you over to Substack. It's a place where we talk about stuff that may not make it into the video. It's absolutely free to join. It's a newsletter site. You can join on a paid tier if you want to, but you don't have to. That's only for people who want to support the channel monetarily. I don't put anything on Substack that people have to pay for. If you don't want to go to Substack, but you'd like to support monetarily, I'll leave my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.